Thank you very much, President Charles Kanjama. Allow me to ride on the protocols already established. I can see time is much spent, so I will try not to say too much. But you look lovely tonight. Well, that was to you guys. You look lovely tonight. This really is a celebration, and if what we have in the room tonight is the best of the bar, I would think that you would not look so grave. Really, don't look so grave. It's a celebration. I mean, you made it here. You made it here, you've been recognized, and it's a good thing. And so try and relax, take it easy. Life is for the living, and life is beautiful. When I got the invite to come and speak here today, and I say this because I've already warned him that I was going to say something about it. You know, the letter that invited me, after saying many things, it said, you need to come and speak, because there are very many ladies who look up to you. So I wondered, so why ladies only? That was a faux pas. I believe that it meant to be ladies and gentlemen. But let me say, it was rather pleasant to know that there are some ladies who look up to me. I hope they are in the room. But I also like to hope that the gentlemen also do look up to me, because I do look up to many seniors who are here tonight, and who blazed the trail that many of us followed thereafter. George, thank you for stepping in and for speaking before me. I appreciate that. I thank you for the reflections that you shared with all of us. They are important. Allow me to take a few minutes to also share my reflections. I was asked to talk about a view from the bench, so that you are likely to hear more from the perspective of litigation. I spent many years as a litigator myself, and I loved it. And when I taught some of you at the School of Law, you remember I would always say that it is in litigation that the rubber meets the road, and that there's something about it, about being a litigator. But let's not take away from those who do conveyancing and other work as well, because excellence cuts across the various fields, and you are being recognized here tonight because of your ability, of what you have achieved so far, to be at the top of your game. Allow me to first of all say that the things I'm going to talk about today, it will feel in a sense like I am preaching to the choir, because you are here because you have done the best in these areas. So if what I say, you feel like saying, I know that already, it's okay. Once, not too long ago, I was sitting in a church in Atlanta, Georgia, and my little niece, 9 years old, very brilliant girl, was seated at the front like all kids. And so they invite someone to come and give the children's story, and the speaker made the mistake of wanting to speak about Zacchaeus, the short man of the Bible. And the little girl, Liana, when the question was posed, who was that of Zacchaeus? And she said, everyone knows that story. You're telling us that story, everyone knows it. And then you could see the speaker was Caucasian, and she turned all crimson on her face, thoroughly embarrassed. So you are at liberty to say, you can shout at this way and say, we know that already, then I will stop. Let me talk about, first of all, I congratulate you. Let me reflect on the need for continued creativity and originality. You wouldn't be here if you hadn't done something extra and something different from what everyone else does. And I think that in a world that changes so fast and a profession that always changes so fast, it's important to be able to be creative, to be innovative, to be original. I think that we must be willing to think outside of the box. We must eschew the silo mentality, and we must also eschew, I think, a situation where we are just an echo chamber, talking to each other the same way, saying the same kind of stuff over and over and over again. I want you to spare a thought for the judge who daily hears the same arguments presented in exactly the same way, and try to be a little different. Because I think being creative, being original, makes someone say, instead of saying, I've heard that before, they're like, wait a minute, I haven't heard it put in exactly that new way. And it does make a difference. When I joined the court, 13.5 years ago, believe it or not, nearly 14, I may have said this to some of you, I had a problem with advocates who took too long, saying the same thing over and over and over again. And when I raised that with my colleagues, my seniors, who were a lot older than I remember being told, come on, judge, let counsel exhaust himself. And my standard answer always was, counsel has every right to exhaust himself, but he doesn't have a right to exhaust me. Right? So think, be creative, be original. I used to tell my students, it's all about persuasion, right? And persuasion is an art. So you need to make it, after all, don't you hear speeches all the time? Don't people say the same thing all the time? But you will probably remember somebody who put it differently. So be innovative. And think outside the box. And in this regard, I want to say one of, in my years in practice, on the bench, one of the things I wonder about, I have this thing for the Constitution, and I've always wondered why so many years later we still call it the new Constitution. It's no longer new. 2010 to now, how many years are those? 16 years. Those are many years. It's no longer a new Constitution. But I ask myself, where are the warriors of or for the Constitution? Where are they? I know many of you do litigate constitutionalism, constitutional issues before us, but I tend to think that we could do more. We could have a lot more people litigating this Constitution. A lot of stuff that is packed in that Constitution, and a disclaimer here, I was a member of the Constitutional Conference at Bombers of Kenya way back around 2002, 2003, before we moved on until we got what we got. There's a lot that is in there, but I don't see enough creativity. I don't see enough of us as lawyers going out there to try and push the boundaries, to try and push the Constitution to see how much it can take and how much it can mean. And I think that it is, and this gentleman I'm going to mention tonight, I respect them. For me, it's hats off for them. But I think he says something about us when we find that the biggest champions for the Constitution, the biggest litigators for the Constitution, the greatest public interest litigators in the country are actually non-lawyers. the umtatas of this world. Dr. Gikenyi, right? The gentleman who appeared before us wearing the theater scrubs and stuff, right? And then he's arguing, dissecting the law, right? And I wonder, shouldn't we have more lawyers doing this? So I want to encourage you, those of you who are litigators, please do more in the area of the Constitution. I think about, talk about originality. Think about the attempt to alter our Constitution some years ago, and how some of you, wonderful, great thinkers in the law, came up with the basic structure doctrine, something that was birthed in, well, first of all, given full expression, if you wish, in India, in the Kesavananda case, way back in 1973. Before I was put to sit in that bench of the Court of Appeal to hear that matter, it happened that about a month or two prior, I was dealing with something to do with this vetting business which never dies. And this particular magistrate had decided that in order to make his case, he would cite the Kesavananda case. So I see one authority, a huge thing like this, and I'm like, what is this guy thinking? How can you bring this thing for me to read? But as I read through, I was very, very intrigued. And the question I posed, Julius, you are my classmate at the university. We were at the University of Nairobi studying law in the year 1988. This was 15 years after Kesavananda. But guess what? No one mentioned the basic structure. I never came across it. We never had it. I'm coming to hear it many, many years later, almost 30 years into the law, and I wonder, what is it that we're not doing right? And I tend to think that we are more comfortable in the beaten track. And I think we need to remember Robert Frost and the road not taken. And we need to do more about going down the road that is not taken and strike new paths. I think about those of you who litigate in the ELC. And I ask myself, how is it that when you look at the Constitution, when the Environment and Land Court was established, please note, it was the Environment and Land Court. But is it not true that 90% or more of the cases at the ELC are about Mogoda? It's about land. But if you look at the Constitution, there's a promise there about environmental justice. And I think a lot more could be done in that area. We don't. And I could mention many other areas that we could do more about, but we don't go there at all. And so I am saying, let us think outside of the box. Let us do more. I am thinking that perhaps what we need is we need to move towards to searching for a heterodoxy. I don't know what that is. Heterodoxy, I think that's right. Heterodoxy of law. That instead of just thinking about things from just a narrow way, the known way, let us think more outside. Let's avoid insularity and let us think more outside of that which is always done. The next thought I want to share with you, talking about innovation, creativity, and originality. The next thought I want to share with you is thoughts about accountability. Accountability. Sometimes sitting as a judge, you look and wonder what is happening in our society. I don't mean the LSK. I mean the Kenyan society generally. And I think that the biggest problem we have in this country is a lack of accountability. I think people literally get away with murder, Chairman Kivuva, in this country. People get away with murder. People get away with murder in the professions. Lawyers mess up their clients big time, not the ones in here. But there are times, you look at a case and as judges, you say, this guy had a good case. But see how it was framed. See how it was presented. But you guys, not you guys, your friends out there, they never will say, I messed up. Guess what they will say? The judge never understood me, or the judge was seen by somebody on the other side. But it's just the way in which the case was crafted. So we need to take accountability sometimes and be humble enough to say, I made a mistake in this one. 2, talking about accountability. Once upon a time, you remember this, we all know this, that a lawyer's word is his bond, right? Back in the day, if someone came and asked for an adjournment because they have gone to hospital, they have not, someone comes to ask for an adjournment because counsel A has gone to hospital, he's unwell, we would believe it, right? The bench would believe it, and everybody in that room would believe it to be true. But guess what? These days, how often do we see someone has asked for an adjournment and then move out of the Supreme Court building an hour later, walk in town, and guess what? Counsel ambaye alikuwa mgonjwa mahututi yu pale mtaani, very well, healthy, and basically having a good time. Somebody came to court and lied. Not to mention, of course, the number of relatives that we kill in order to get adjournments. So an auntie today, a cousin today, a mother the other day, and then 2 years later, the same mother. Lies. And I think that really, we ought to be at a place where we know that, look, our word means something. You call your colleague and say, look, I'm going to get the check, so please don't send auctioneers, right? I'll get you the check on Wednesday, next week. That's what I've been told, please hold, right? And then he tells you, okay, that's fine. I'm going to do what? I'm going to hold. And then Friday at 2:30 p.m., the auctioneers are right there because he gave you his word, but he lied. I think it's a failure to be accountable to your colleagues in the profession, and failure to be accountable even to yourself and to your own conscience. We see a lot of that. And I want to say something as well, which is this. We see people taking up, if you're a criminal defense lawyer, for example, you know that you need to defend your client as forcefully, as persuasively as possible, but within the law, right? So there's a thin line. When people say, lawyers are liars, that's not really entirely true. Because you say, okay, fine, you say my client did it, prove it, right? But there's something you can't do as a criminal defense lawyer. One thing you can't do, for example, is you should never, ever put forth an affirmative defense which you know to be false. You can't help your client come and swear on oath that, when these things happened, I was actually, attending a ceremony, let me say this, that I was attending a koito in the village of Chemundu in Nandi. That's where I was. When you know very well that's not where he was. That's an affirmative defense. You must never encourage your client to put forth an affirmative defense that you know to be false. You can be quiet. You can challenge everything. Even the person who saw him there, you can challenge him whether it's actually him, how was he dressed, etc., etc. That you can do. But you can't say he was at place A when you know he wasn't at that place A. But that happens a lot, right? And lawyers get away with it. Now, I have a theory myself. Not a theory. I have what I think to be the solution to some of these problems. I think the problems we have in Kenya, which contribute greatly to the lawlessness we see in our land, are because, one, and perhaps we are to blame as judges, we do not sufficiently punish perjury. We don't, in fact, we never punish perjury. Someone stands up, or well, no, they stand or sit when they do their affidavits. Yeah? Someone swears an affidavit that is false from beginning to end. and we find that the person actually lied, that the affidavit was false, but we as judges, we as judicial officers, we do not punish perjury. I think we ought to. Because if we did, then even you, in fact, in other jurisdictions, you say, I swear this affidavit, fully aware of the penalties of perjury. So that, and you should be able to warn your client, if you swear falsely, you're going to be in trouble. Oh, but I think too many advocates are more than happy to not care whether that is, which is being said, is true or not. And that needs to change. You can imagine if people did not swear falsely because they would be punished, then even you, as you face a case in court, as you go to litigate, you know you are coming from a place of confidence that what my client told me is true. So you can push it with as much energy and as much passion and much persuasion as you can. The second problem, I think, which needs to be sorted out, and I think the judiciary needs to do that, is contempt of court. We never sufficiently punish contempt of court. President Charles Kanyama, am I moving in that same direction of being harsh? I'm sorry. But I think we need to. Because court orders, if your court order, the court order you received today, is ignored, if the court order is disobeyed with contumacious disregard, surely then what is the purpose of a court order? In other jurisdictions, when someone tells you we'll meet in court, someone actually gets to worry because they're going to meet in court, and if you are in the wrong, you're going to be discovered, you're going to lose it. So we don't actually punish that. But I want to say this, thirdly connected to that, is that, and this part of accountability, I think that the bar perhaps needs to do more in terms of holding your colleagues who are errant to account. You know the lawyers who deal with clients' money in a particular manner. You probably haven't punished them enough. And I think, sorry, I'm not saying that you should go change your laws, but just think about it. Are the members of the DC elected? They still are elected? Do you see a problem there? Hello? Do you see a problem there? Do you choose which votes? Do you say I'll get votes only from the good guys? Or do you get votes from everyone? You get goats from goats. Well, not goats. You get votes from everyone. And I think that is the problem. How much you can do, especially if you seek to be re-elected, perhaps will be, in a sense, stymied by the fact that you will be looking for votes. I was speaking to a judge from some jurisdiction not too long ago, and he told me that for them, and please don't quote me, and don't get me wrong, I'm not saying that's necessarily what should happen, but they said for them, the chair of the disciplinary council is actually a senior judge. He's not elected, so he doesn't have to worry about being nice so that he can get re-elected, right? And then I also know that in other jurisdictions, it's not even the courts that lawyers have to fear. It is the bar leadership that they should fear. Because you say, the judge says, I am going to refer you to the bar council. And the bar council will deal with you. And I think it's in the best interest of all of us that we should actually root out those who are bringing our profession to disrepute. And let me say this as well. Senior, and all the seniors around. You know that when we were much younger in the profession, rarely would you see lawyers having an exchange with magistrates and judges, right? Never did. That was never it. But isn't that commonplace these days? Fredo Jambo, senior. I mean, in your days, when you were in practice, I'm sure it never happened. But these days it happens. And unfortunately, with great respect, unfortunately, some of the culprits are the not so young as well. people who are senior, and people who therefore should be, setting an example. Unfortunately, what the younger people will think is that that is the way to go ahead, by taking judges and magistrates head on, by being intemperate. The other day, I will not say who it was, but somebody came out of a courtroom and made a scurrilous comment about a judgment. You know what they called it? This is judicial. I mean, how does anyone honestly do that? When I used to teach over there, I remember quoting from a letter that one senior lawyer wrote to his son who was joining the bar. And he said that, when you lose a case, don't burn down the courthouse. Don't burn down the courthouse because you lost a case. So when you lose a case, just take it manfully, right? Take it manfully. It's just a case. Don't be over-invested in any one case. And remember that courtroom is the place where you make your living, right? So I want to suggest very strongly that we need to reflect on accountability. And if there is anyone in the profession who would help in that enterprise, it is the people here, because you are the best of the best, right? So please bear that in mind and see what you can do. The final one I want to mention to you is humanity. This I've always said. We are lawyers, but before we were lawyers, we are first human beings. And long after we've hung our practice boots, we will still be human beings. Now, this idea that lawyers, I've mentioned before, that lawyers are liars is not a good thing. This idea that lawyers are heartless is not a good thing. You know what they say around here? Ogopa wakili. Hello? Ogopa wakili. You'll get, what do you call it? They call it something. Character development, right? Character development being constant, right? But what I'm saying is, I think that let us be human. Let us be human. And even though some guy wrote a book called Lawyers and Other Reptiles, I think we should not be reptilian. Let us avoid being reptilian. Let us be at that place where our word is our bond. Let us be people of integrity who are able to be true to self and true to God, whoever you conceive him to be. There's a character of Shakespeare's who said, "This above all else, to thine own self be true, and it would follow as day follows night, that thou would not be to another false." All the people who lie around, who are being false to other people, the problem is that they are not being true to themselves. So let us be true to ourselves. Let us stand for that which is right. For every land grab there is in this country, there is some lawyer involved in a conveyancing. True or false? So that when now we start coming up with, it's interesting how this country, we have changed, we have moved goalposts about the jurisprudence on land law, right? You know that. There was once a time we said the title is sacrosanct, so long as you have a title, good. Later on we said if there are two competing titles, the first in time carries the day. And then we discovered there's a problem there. So now, where we now are, dinner management and so on from the Supreme Court, we are saying you must go to the root of title. And I remember applying root of title myself. I said that, I quoted from Chinua Achebe in one of my judgments and said, is it Nze or Nzi the Bad said that since men have learned to shoot without missing, I have learned to fly without perching. So the judges, the courts have had to try and fly without perching, because if you don't, you're going to be taken to the cleaners by, you write a beautiful judgment and all along it was a false trail you are following. And then you give judicial imprimatur to what was really a land grab. So it's a problem that we have there. And I just want to say, take a moment to it's better to lose it's better to lose a brief, no matter how big, than to lose your soul, really, in the end. Because, believe it or not, I believe with all of my heart that after we have done here, there's an accounting to be done somewhere to he from whom no secret is hidden, right? So let me finish by quoting two people. I said, don't be heartless. So I say, have some empathy. One of the things that used to shock me and is this. You know, way back, running down was a thing in this country, right? In this town, running down. Lots of lawyers made lots of money with running down cases. But it was not, now you get to see that an accident occurs somewhere in Tharakaniri on the bridge there. The bus had 30 passengers, but somehow 120 claimants are able to file cases. A lawyer somewhere is involved. A lawyer together with an ambulance chaser, they are creating all of these things. A whole edifice of falsity and fraud happens, and lawyers are involved, right? That's one aspect. The other aspect is, how often, I mean, you know this, someone gets injured, they get paid damages of say 3 million shillings, and then the lawyer keeps 60 or 70% of that. Excuse me? Is it your head that was cracked in the accident? Is it your ribs? Are you the one who lay in that hospital for that long? How do you take away 60% of a guy who was injured? Have you no fear? Have you no fear of a God? And have you no fear, if not God, have you no fear of something called karma? And karma, as you know, is a beautiful someone. I mean, the point is, have you no fear? So that it's only when you have no empathy that you can do those kind of things. So there's a lady called Audrey Hepburn, and she had this to say about empathy, and I want to share that with you as part of that thing of being human. And this is what she said. Audrey Hepburn said, nothing is more important than empathy for another human being's suffering. Nothing is more important than empathy for another human being's suffering. In this country, I see people celebrating people's suffering. And it happens, especially on social media. I mean, I remember, I won't name names. I remember somebody losing their child. And then hundreds and upon hundreds of people on social media celebrating a mother's heartbreak. So there's a deficit of empathy we have in this country. And I don't know what's going to happen. I think we all need Jesus. Really, we do. So anyway, nothing is more important than empathy for another human being suffering. Not a career. Hello? Not a career. Not your fees. That's not more important. Not wealth. Not intelligence. Certainly not status. We have to feel for one another if we are going to survive with dignity. I think that if we had a more empathetic bar, we'll have a better society. I truly, truly believe that. And now, as I sit down, let me read to you from a guy. J.G. Holland was an essayist. He was a poet, an American poet. He was a thinker. He was every good thing. He was a preacher. He was all manner of things. And one of the most beautiful little poems I ever came across that he wrote is titled, God, Give Us Men. Hello, what did I say? What did I say? God, give us men. He said, God, give us men. A time like this demands strong minds, great hearts, true faith, and ready hands. Men whom the lust of office does not kill. Men whom the spoils of office cannot buy. Men who possess opinions and a will. men who have honor, men who will not lie, men who can stand before a demagogue and damn his treacherous flatteries without winking. Tall men, sun-crowned, who live above the fog in public duty and in private thinking. For while the rabble, with their thumb-worn creeds, their large professions and their little deeds, mingle in selfish strife, lo, freedom weeps, wrong rules the land, and waiting justice weeps. Ladies and gentlemen, God give us men and women of this kind, because then we can have a better bar, a better country, a better society, and we just might have a better chance of seeing life eternal. May God bless you.